if you see here that the commission said, the operator acknowledges that those lease terms do not authorize it to pull the tracts as it desires. The operator is seeking a commission field rule that would endorse its desires to effectively amend the terms of its agreements with the mineral owners, authorize it to combine the tracts, and direct that the mineral owners be paid in a manner different than is provided in the lease contracts. Now, notwithstanding that initial decision in 2009, sometime after that, the Railroad Commission started issuing permits for these types of wells that don't have production sharing agreements or pooling authority. And they're called allocation wells. And what the industry has proposed is that they drill these wells and then the operator just allocates the production amongst the different tracts based on an estimate of how much is produced from each tract. Now, there's no regulation that authorizes it. It's just something that the commission started doing without really issuing regulations, and it kind of went unnoticed for a couple of years. Then in 2013, a group of landowners contested a drilling permit for an allocation well. Those families, they were members of the Klotzman family, and that's called the Klotzman case by a lot of treatises. And in that case, the landowners argued at the Railroad Commission that these sort of allocation wells are forced pooling that are not authorized by leases, and that the commission could not authorize permits. I think it's noteworthy that in the Klotzman case, the General Land Office, which manages about 13 million acres of state-owned mineral interests, intervened and argued that these sort of wells are in effect forced pooling and therefore not authorized by state law. And what's worth noting is that in the Klotzman case, it went to an adversary proceeding at the Railroad Commission in front of hearings examiners, and the hearings examiners agreed with the landowners and with the General Land Office and said that these types of wells are illegal under state law and is a type of pooling. And I've attached that proposal for decision from the Klotzman case as Exhibit 4 to our motion for summary judgment. Now that went up to the commissioners, and the commissioners overruled the holdings of the hearings examiners. Didn't really provide any explanation, just kind of overruled them and issued the drilling permit. That was in 2013. And in the very next legislative session, 2015, the Texas legislature, some members of the Texas legislature tried passing a statute that would have authorized allocation wells, would have made these types of wells legal. And that was House Bill 1552. I didn't attach it as an exhibit, but I cited to it, quasi-statutory materials. The court would like, I could provide copies of the legislative history.
I can pull it off the state webpage if I need it.
Okay.
Thank you.
And the House Bill 1552 had a lot of support from the oil and gas industry. We faced a lot of opposition from landowner groups. The General Land Office and the University of Texas system, which also has a lot of oil and gas interests, the Permanent University Fund, they filed a fiscal note in the committee, and it said that the statute authorizing allocation wells would have denied the state and other landowners the right to negotiate their lease terms with their lessees, and it would have cost the state close to $500 million in oil and gas revenues a year because of that loss, because of losing that right to negotiate. Now that bill never made it out of the committee. In the face of this fiscal note, and the opposition from landowner groups died in committee. And one thing that I think is worth noting is that even though the Railroad Commission has been issuing these permits for the last 10 years now, in every single permit application for either an allocation well or a PSA well, the commission includes a conspicuous disclaimer that says, the commission is expressing no opinion on whether these sort of things are authorized in the absence of a pooling agreement. So, Judge, it's with all of this legal controversy in the background, all of these, every time any state agency has been asked to write an opinion analyzing the legality of these sorts of wells, they've held that that they're not legal. Right? That's what the court held in Browning, and it's what the Railroad Commission has said twice in in-depth analysis. And those analyses by the Railroad Commission were overruled by the commissioners, but they didn't write an opinion. And ever since then, if anybody challenges a permit at the Railroad Commission, the commission just points back to the Klotzman case and says, well, this has been decided by the commissioners. So with all of this in the background, in May of 2018, Enervest, who was the lessee at the time, asked the Railroad Commission for a permit to drill an allocation well on the Opiellas land. The Opiellas filed a complaint with the Railroad Commission. So the permit was granted on May 3rd, and the Opiellas filed a complaint on May 11th, basically as soon as possible. They filed this lawsuit about a month later. In spite of the complaint at the Railroad Commission in this lawsuit, Enervest started and continued to drill the well. Sometime in the summer of 2018, Magnolia took over for Enervest and continued drilling the well and completed the well and has since produced oil from the well. Further complicating matters, in the summer of 2018, Magnolia filed an amended permit application with the Railroad Commission, and they changed the status of this well from an allocation well to a PSA well. And as I briefly touched on earlier, just a few minutes ago, the difference between an allocation well and a PSA well is that in the PSA well, 65% of the working interest owners and royalty owners sign a production sharing agreement. In this case, the MPRI owners signed consents to pool, and that's what Magnolia relied on to say that this is a PSA well. At around that same time, that's when they filed the pooled unit designation, creating the Audioslave unit. So I think what all of this shows is you have the Audioslave well, which began as an allocation well, and then it changed to a PSA well, and then it changed into a pooled unit well. And
let me ask, to the defendant's response saying that that was only a preliminary filing or a filing that wasn't necessarily effective right away, but only if it became a gas well?
No, so this well is an oil well, and the pooled unit designation purports to pool, I'll pull it up real quick. It purports to pool not only for gas, it pools for oil, gas, and other minerals. Let me pull it up and I'll give you the exact language. Yes, so it says.
Go ahead.
It says that the parties hereby pool, consolidate, combine, and unitize the leases, the leasehold rights, overriding royalty and royalty interest therein and thereunder, including all renewals, for developing and or producing oil, gas, and liquid hydrocarbons. Now, in Magnolia's response, they say that um, they could do this because they're allowed to pool for gas wells. And this goes back to what I was saying back in 1955 when this lease was negotiated. Oil wells were drilled on 40-acre units. Gas wells were drilled, I believe, on units that were over 600 acres. So back then, it would have made sense to give them authority to pool the property for gas, but not for oil. And here, the defendants have purported to pool for oil, and this is indeed an oil well. Defendants say that it may change to a gas well in the future, but there's no evidence of that in the summary judgment record. The only evidence is that this is an oil well.
Okay.
But as I was saying, so there are these three labels that defendants use simultaneously for this well. Like I said, it began as an allocation well, then they changed it to a PSA well. And for some royalty owners, the defendants say that it's a pooled unit well. And my question is, how can a well at the same time be considered an allocation well and a PSA well and a pooled unit well? And that just goes to show that these three labels, Judge, they really, they mean the same thing. And uh, the term pooling means and has always meant the aggregation or combination of multiple tracts to uh, for the purpose of drilling a single well. So when you combine multiple tracts into a single drilling unit, that is pooling. Now, like I said, the lease expressly prohibits pooling. But one of the main disagreements that we have with the defendants is what the term pooling means. In their response, defendants argue that the term pooling should have a very narrow definition. They say that there needs to be certain hallmarks present for it to be considered pooling. In our reply brief, Judge, on pages 11 and 12, I quoted a handful of different sources that all quote pooling the same way, and I'll just share my screen real quick so that the court can see that. But oh, hold on. So the Professor Smith and Jacqueline Weaver's treatise, Texas Law on Oil and Gas, defines pooling as pooling occurs when tracts from two or more leases are combined for purposes of drilling a single well. Black's Law Dictionary defines pooling as the bringing together of small tracts, usually in association with spacing regulations. Professor Brett Wells defines it the same way. There's a Texas Law Review article from 1943 that uses the same definition, and Texas courts have used that definition. Defendants cite really just one authority for their argument that the term pooling has a very specific and defined meaning, and they cite an article by Professor Ernest Smith that he wrote, I believe, in 2017. And what Professor Smith said was that pooling only occurs when there's a cross conveyance of interests. And that's generally the case. Generally, when two tracts are pooled, the royalty owners engage in a cross conveyance in which the royalty owners from tract one obtain an interest in tract two and vice versa. But that is not something that is necessary for something to be considered pooling. And in fact, Professor Smith's narrow definition of pooling contradicts some of his own writings. Back in 1966, Professor Smith wrote an article about the Texas Mineral Interest Pooling Act. Texas has a compulsory pooling statute that applies in very limited circumstances. And in a law review article that we cite in our motion and in our reply, Professor Smith said that the cross conveyances theory wouldn't apply to tracts that are pooled under that statute. in our reply, I also cite a couple of cases. One is a Texas Supreme Court case, and that's the Sampson case. And in that case, someone argued that pooling was ineffective because it failed to convey title. And the Texas Supreme Court said, even if a pooling agreement fails to convey title, it's still enforceable as a contract. I think even more on point, we cite a case out of the Tyler Court of Appeals, and it's actually a property tax case, but that case involved a lease that allowed pooling but prohibited cross conveyancing. And that case involved a pooled unit that straddled county lines. So the taxing authorities in both counties tried going after everybody that owned an interest in the pool. And one of the owners argued that he only owned an interest in one county. And the taxing authorities argued, well, your interests have been pooled, there's been a cross conveyance, so you actually own interest in both counties and you need to pay property taxes in both counties. And the Court of Appeals held, as a matter of law, that the lease allowed pooling but prohibited the cross conveyance, and there was therefore no cross conveyance. So that argument, and I believe both of those cases came out after Professor Smith published his article. But the long and short of it is, the one authority that they cite for their argument that pooling, that these sort of wells aren't in fact pooling, that authority is based on a flawed premise that there needs to be a cross conveyance for something to be considered pooling. And moreover, Your Honor, this lease in the language that prohibits pooling, it says that pooling shall not be authorized in any manner whatever, right? So that any manner whatever language is pretty broad. And I think the only way to interpret that language is it prohibits pooling and anything that looks like pooling. And this certainly looks like pooling. If the lessor wanted, and the lessee wanted to give some technical narrow definition to the term pooling, they wouldn't have used such expansive language in the lease. In our motion and in our reply, we cite a law review article by Professor Brett Wells. We appended that article to our reply brief, so the court should have a copy. But Professor Wells is a leading authority in the area of oil and gas law, and he's frequently cited by Texas courts, been cited with approval by the Texas Supreme Court. And he says that these sort of wells are not authorized in the absence of express pooling authority. His analysis is it's lengthy. It goes into the regulatory background, goes into Texas case law interpreting leases, and I would ask the court to give that article a look because I think it's quite persuasive. So that's really what it comes down to on the issue of breach of the lease. The defendants have pooled the property, and they weren't allowed to do that, so they breached the lease. And the court can hold as a matter of law that the lease has been breached, and then the issue of damages we can talk about another day. And that brings me to the issue of trespass.
Let's do these one at a time so that I can keep the arguments a little fresher.
Okay.
All right, Mr. Hanna.
Your Honor, we've prepared a presentation that would go through the background and then breach of lease and then trespass. And so if you'd like us to do the background and breach sections,
Sure.
we can, and then come back to trespass.
Sure.
Okay. All right, thank you, Your Honor. Again, I mentioned earlier, I'm Mark Hanna with Scott Douglas and McConico. Also with me today is my law partner, Brian Lauer. And we represent all of the intervest defendants in the case, and Magnolia, which is the current operator of the well. Mr. Cook represents Compass, which is a working interest owner in the well as also. So the plaintiffs want to keep it simple. Their argument amounts to essentially 3 points. There's a lease that doesn't allow pooling authority for the well. There's a law review article that says drilling across multiple tracts is pooling, and therefore it was a breach of the lease and a trespass to drill across multiple tracts. Stop there. Don't look any further. But when we scratch below the surface, there's really no substance. The plaintiffs don't cite a single case that's previously made any of the holdings that they're asking this court to make here. No case in Texas has ever held that completing a horizontal well on multiple tracts is pooling. No case has ever held that drilling across multiple tracts without pooling authority is necessarily a breach of the lease. And no case has ever held that a lessee who drills to access its own minerals with a valid lease is trespassing. And what the full picture of the facts and the law show is that there's not been any breach of the lease or trespass in this case. And why? Well, the biggest reason is pretty straightforward. Magnolia and its predecessors in Intervest have always held a valid and subsisting lease on this property that is not in dispute. So our argument, like I mentioned, is split into 3 parts. We'll do the background and I'll do the background. Mr. Lauer is going to argue breach, and then we can go back to Mr. Aller-Cohn to argue trespass, and then we'll come back and argue trespass. So I want to kind of revisit some of the concepts that Mr. Aller-Cohn talked about, because I think it's important that we have a good context for what's happening here and how oil and gas has developed in Texas. And really the development of oil and gas in Texas over the last 100 years has been a story of evolving technology. And the law in Texas has had to adapt to keep up with that technology. And as the court knows, what's been most significant over the last 20 years is, of course, breakthroughs in horizontal drilling and fracture stimulation. So a vertical well is only a few inches wide, and so its contact with the formation is limited to the thickness of the wellbore. Whereas a horizontal well is only limited in the formation by the length of the well. So a horizontal well can in effect do what hundreds of single vertical wells would have done. And that's of course more efficient. You've only got one vertical portion of the well. It's less disruption on the surface. You've only got one surface location. And it's allowed operators in Texas to unlock tight oil and gas reservoirs. So those are reservoirs with low permeability, low porosity. It's hard for the oil and gas to move through the reservoir. And that's what horizontal drilling has allowed. Now, the reality, of course, is that a lot of tracts in Texas are not long enough or big enough to accommodate these long wells. And so these long wells are drilled across multiple tracts. Could be old units, could be a single tract or a single lease. And so it's sometimes necessary to drill these longer laterals across multiple tracts. How have operators done that? Well, there's 3 different ways you can permit a multi-tract well at the commission. The first, of course, is a pooled unit. Now, that's the long-standing concept. It's been around for quite a while. And the classic pooled unit, the royalty gets allocated on a surface acreage basis. So your proportion of the acreage that you contribute to the unit sets out how much of the production is going to be allocated to that tract. Another key concept of pooling is that operations and production anywhere on the unit are deemed to have occurred on every single tract in the unit. The second way that the commission permits a multi-tract well is with a production sharing agreement. Here, royalties are allocated by contract. It could be whatever method the parties agree on. So you could draw a radius around the well, and we're going to allocate royalties to whoever falls within the radius. You could do it on an acreage basis, just like a pooled unit. You could do it on the length of lateral, how much falls on each tract. But it's whatever the parties agree to. A production sharing agreement is just a contract, okay? And if you're going to permit one of those at the commission, you've got to represent that you have 65% of the working interest and the royalty interest in each tract that you cross signed up to some form of a method on how you're going to allocate royalties. The third way that the commission allows a multi-tract well to be permitted is with an allocation well. And it's similar to a PSA permit, except that the operator doesn't have to make any representation about how much sign up it has to a production sharing agreement or a pooled unit or some allocation method. Instead, the operator takes it on itself to allocate the production. They may have 100% signed up or 0% signed up. The commission says, we're not going to look into that. We're going to call this an allocation well. So those are the three permits available. Now, these permits started coming into existence in 2008. And since then, there's been more than 9,000 allocation or PSA wells drilled. A quarter of all new horizontal wells being drilled in Texas are PSA or allocation wells. And if you look at this map, the red dots are PSA and allocation wells throughout the state. And what this map shows is the story of oil and gas development in Texas. You can see of course, the Midland Basin, the Permian Basin. You can see the Delaware Basin, the Barnett Shale, and then, of course, you can see the Eagle Ford Trend over which this court sits. Now, PSA and allocation wells are also found in Karnes County. There's these red dots are all the PSA and allocation wells in Karnes County. The well we're talking about today, the Audioslave well, is this yellow star. The production from PSA and allocation wells has been just nothing short of tremendous. 1.4 billion barrels of oil, 6.3 trillion cubic feet of natural gas. That's enough oil to keep every car in America running for 153 days. It's enough to heat every home for more than a year. It's also generated a lot of tax revenue to the state of Texas, $1.8 billion in severance taxes, and just in Karnes County, $57 million. The plaintiffs, with their attack here in this court, and then a parallel proceeding at the Railroad Commission, are saying all of this production was illegal. So what's the, that brings us to this case. What's the lease in this case? Well, there's a 1955 lease that Mr. Alarcon mentioned. And his clients, Adrian Opiella and Adrian's sister, Elsie Opiella, own a part of the royalties that are produced from this lease. They each get 1/8 of the royalty. Mr. Opiella owns the surface, and then together they own the executive rights on behalf of a bunch of non-executive owners that own the other 75% of the royalties that are produced. Now, one thing that's important to notice about this lease is that it's a 1950s lease and it's got a 1950s royalty. So it's a 1/8 royalty lease. If you read the plaintiff's reply, what you're going to see is that that's one of the things that's motivating this lawsuit. They're upset that they still have a 1/8 lease and the royalty rate in Karnes County is now something higher than that. And what they're asking the court to do is use a trespass action to reform the terms of their lease and give them a higher royalty. That's not Texas law, but that's what they're trying to get at. Here's what here's the land, just an aerial shot of the land covered by the Opiella lease. So what you'll see is these blue wells are Austin Chalk wells. So that's the shallow formation here. And then these orange wells are Eagle Ford wells. Now, all of these wells have been drilled entirely internal to, they're completed only on the South Tract. And by completed on the South Tract, I mean the perforations of the wells where they actually produce from the reservoir is on the South Tract. Some of these wells have some heels that come out of the South Tract, but the completions themselves, all of these wells are on exclusively the South Tract. There's a highway tract that runs north on the north boundary of the lease, and then there's another tract that we call the North Tract. And the subject well was drilled across those 3 tracts. Now, Magnolia operates a lease on all 3 of those tracts. That's not a dispute. So the surface location is up here, just outside the North Tract. And then the well is completed with perforations on the North Tract, underneath the highway tract, and then underneath the South Tract. So this is the layout of the subject well. Now, why was that well drilled there? You notice that all of these wells stop just short of the northern portion of the lease. And that's for an important geologic reason. There's a major fault that separates the north part of the lease from the south part of the lease. There's also another fault that runs up here just north and kind of behind the heel of the subject well. This area between here, between the 2 faults, is called the Karn's Trough. The Karn's Trough is much deeper and it's more fractured. So if you want to make a good well in the Karn's Trough, you have to drill a longer lateral. And you can't drill across it because 180 feet of throw is too thick to then get your well down into the reservoir once you go across the faults. So the Audioslave well was drilled to slot in here right in the Karn's Trough. This is just an illustration. This isn't to scale, but it's an illustration of the cross section. So if we had a sideways view through the earth of the well, this is what it would look like. You have the surface location of the well here. The vertical portion goes through the North Tract. And then once it enters the reservoir, it turns. And now you start having perforations through the North Tract, the highway tract, and then the South Tract. It's 10,000 feet deep. So if you're standing up here on Mr. Opiella's surface, you don't know the well is there. You can't see it or hear it or feel it. And it's an Austin Chalk well. The Eagleford is just below the Austin Chalk. So this is a timeline. It's a little busy. I'm going to tell you what we really need to focus on. On May 7th of 2018, Intervest began drilling the well. So Intervest was the operator in May. In a little over a month later, this lawsuit was filed. And then over the summer of 2018, Intervest sold its interest to Magnolia. So Magnolia became the operator of the well. It took over operations and started producing the well in December of 2018. The plaintiffs have filed a lot of petitions in this case. There's been a little bit of motion practice, but very little discovery in the case. And in the meantime, there's been a separate case happening at the Railroad Commission. So on May 3rd, the commission granted a well, or granted a permit for the well. The plaintiffs, as Mr. Alarcone mentioned, filed a letter complaining about that permit, but they didn't serve it on Intervest until May 11th. After the well had already been rigged up, the rig moves in, they spud, they spent a lot of money to get the well drilling, then the complaint is served on Intervest. Eventually that was transferred to Magnolia and the complaint was docketed as a complaint against Magnolia. That went through a hearing and the commission denied that complaint. The plaintiffs, who are called the complainants over at the Railroad Commission, the complainants appealed, and that appeal is now pending here in Travis County. And it's set for a sort of what would be the equivalent of an oral argument this spring. So what did the Railroad Commission find? Well, these are quotes from the proposal for decision, which is written by, you have a legal examiner and a technical examiner at the commission. They write a proposal that gets recommended to the three commissioners, and the commissioners decide whether to adopt or reject that proposal. they made some important findings. First, they said the complainants are putting too much emphasis on Browning versus Luecke. It doesn't say what they want it to say. Second, that the complainants are arguing that Magnolia, by drilling an allocation well, and everyone else who drills an allocation well, is violating Rule 26. What's Rule 26? It's a surface commingling rule. You can't mix oil on the surface without a permit. The commission said that doesn't apply. We're not persuaded by that. And then they made some findings. They found that Magnolia had a good faith claim to operate the well, and that Magnolia's permit should be upheld and the complaint should be denied. That goes to the three commissioners, and the three commissioners agreed. They ordered that the complaint was denied. And they adopted all of the commission's the examiner's findings of fact and conclusions of law without modification. So there's as Mr. Alarcone issued or argued, they're moving on two issues right now. One, they're arguing that Magnolia has breached the lease just by virtue of drilling a PSA well or an allocation well. And then second, they're arguing that Magnolia has trespassed on the lease. I'm going to turn it over to Mr. Lauer, who's going to argue in response to the breach claim.
Go ahead.
Thank you, Mark. Good morning, Your Honor.
Morning.
As Mark indicated, I'm going to be talking to the court about the claim that plaintiffs have brought that Magnolia breached the lease. Plaintiff's breach claim boils down to a single allegation that Magnolia breached the lease by drilling a multi-tract horizontal well. Now, if the plaintiffs are wrong and Magnolia had the authority to drill this well, then all of their claims in this lawsuit fail. Breach and trespass. So let's look at their allegations. Plaintiffs assert 4 ways that Magnolia breached the lease by drilling this well. By drilling the well, Magnolia breached by, first, drilling a well that combines multiple properties into a single unit. Second, pooling plaintiff's interest in an oil well. Third, commingling production. And fourth, paying royalties on an estimated value. But as we're going to see, Magnolia didn't breach the lease in any of these ways because each of these actions were either within Magnolia's rights as an oil and gas lessee, or in the case of pooling interests in an oil well, it simply never happened. Now let's start with the allegation that drilling a well that combines multiple properties into a single drilling unit constitutes a breach. Let's start with how plaintiffs frame this issue of authority to drill the well. The plaintiffs claim that the lease does not authorize the well. They specifically claim that the lease does not allow, and let me get rid of, oops. Yeah. They claim that the plaintiffs, that the lease does not allow the defendant to drill a well that combines multiple properties into a single drilling unit, and that express pooling authority is necessary to drill a horizontal well that traverses multiple tracts. This is taken from their motion for summary judgment. And they cite absolutely no law in their motion for these two propositions because there is none. If the court were to hold that this constitutes a breach, it would be the first court that we are aware of to ever do so in Texas. Instead, they cite to a law review article written 4 years ago by Professor Brett Wells, who has propounded a unique theory, unprecedented, that no court has ever upheld with respect to this issue and a number of issues that we'll be talking about today. Other than that, there is no citation to support this proposition. And the reason is that the plaintiffs completely fundamentally misunderstand the nature of an oil and gas lease and what rights it conveys. The plaintiff's question is does the lease authorize drilling such a well? But the relevant question is, does the lease prohibit drilling such a well? And that's a crucial distinction. Now, why? Why is that the relevant question? It's because an oil and gas lease grants a fee simple determinable interest in the minerals. And that fee simple is a powerful interest. The court is fully aware in Texas, it's longstanding law that an oil and gas lease isn't a lease in the traditional sense. It's a grant. The lessor is a grantor, and he grants a fee simple determinable interest in the lessee, who thereby acquires ownership of all of the minerals in place. And this has consequences. It's well established that the right to the minerals carries with it the right to enter and extract them, and all other such incidents thereto. Okay? Unconstrained by anything other than what is expressly prohibited. Now, it's important to note here that an oil and gas is not an easement in the minerals. Okay? As Your Honor certainly knows, an easement only includes what is expressly authorized by the deed. But a fee simple conveyance, like an oil and gas lease, conveys all authority except what is specifically reserved or prohibited. So the question here is not what the lease authorizes, but what does the lease expressly prohibit? Now, if we look at the granting language in this particular lease, it's classic fee simple determinable granting language. Grants, leases, and lets exclusively unto lessee for the purpose of investigating, exploring, prospecting, drilling, and mining for and producing oil, gas, and other minerals without any kind of constraint. Now, Magnolia has these fee simple rights in all three tracts that the Audioslave traverses. It has a lease for the North Tract, it has a lease for the South Tract, where the OPLs have their interest, and it has a lease in the Highway Tract. And so what does that mean? It means that Magnolia has the absolute right to enter, the absolute right to drill anywhere, and the absolute right to produce oil and gas from any and all of these three tracts. Now, to illustrate the significance of this, an analogy might be useful. Imagine that I wanted to build a house. Imagine that I had two properties that I could buy that were adjacent to each other. So I go ahead and I buy these two tracts. I have a deed to one and a deed to the other. Now, no one would dispute that I could build a house completely on the yellow tract because I have a deed to it. And no one would dispute that I can build a house completely on the green tract because I have a deed to it. And crucially, no one would dispute that I could build a single house that traverses both tracts because I own both tracts. If someone were to suggest I need special authority to build a house that traverses both tracts, we would think that's insane. Now, this applies exactly to this situation. So here we have two adjacent tracts, or in this particular case, we have three adjacent tracts. But imagine we have two adjacent tracts. And I go ahead and I get a lease, an oil and gas lease that grants me a fee simple determinable in the minerals for both. Now, no one would dispute that I have an absolute right to drill a well solely on the green tract, and no one would dispute that I have an absolute right to drill solely on the yellow tract. And just as in the house, no one should dispute that I have the absolute right to drill a single well that traverses both. But that's plaintiff's position here. Plaintiff's position is that we somehow need extra authority other than the grant of the fee simple determinable in these two tracts to build, to drill and complete a well that traverses both tracts. And there is no authority for this in Texas law. There never has been. This is a completely new theory that Professor Wells has put out. Now, Your Honor may be familiar with Ernest Smith, longtime professor at the University of Texas, almost certainly the foremost authority on Texas oil and gas law, who is still living. He has directly addressed Mr. Wells' theory here and the theory on which the plaintiffs rely, and has completely rejected it. He states that nothing in mineral law, the typical mineral lease, prohibits the lessee from drilling a well that goes from one side of the mineral estate to the other. And the fact that that same well may go through a neighboring tract doesn't in any way prevent the lessee from fully developing a particular tract by drilling horizontally through that tract. So the absence of this in an attempt to overcome the absence of Texas legal authority for this proposition, the plaintiffs point to the case of Browning versus Luecke. And Mr. Allocation spoke of this case a little bit in his presentation. And they characterize the holding in Browning versus Luecke as an operator breached its lease. How? By drilling a horizontal well across multiple tracts without a valid pooling agreement. But that's completely wrong. Oops. Sorry about that. But that's completely wrong. The Luecke court never says anything like this. So let's talk about what the facts were. They're very straightforward. Browning was the lessee. The Lueckes were lessors. The leases authorized pooling, but only if 60% or more of the pooled unit consisted of Luecke acreage. Browning went ahead and formed 2 pooled units that included Luecke acreage and drilled 2 horizontal wells, but there wasn't 60%. And so it violated the anti-dilution clause in the leases. And so the Lueckes filed suit. And they contended that the purported pooled units for the 2 horizontal wells violated the pooling provisions of the leases. Now, there's something that's important to point out here. In Luecke, Browning and Marathon, the 2 operators, insisted that the pooled units pooled the Luecke's interests and were valid as to the Luecke's and bound the Luecke's. There was no dispute about that. They did assert that. Of course, the Luecke's claimed that no, we weren't properly pooled, but Browning insisted they were. That is crucially different from what's happening here. Here, Magnolia absolutely does not claim that it has pooled the Opiela's interests as to an oil well. And so that alone distinguishes it completely from Luecke. But let's look at what the Luecke court held constituted the breach here. Was the breach constituted by drilling the well? No. Here is the series of the court's holdings. The court held that the Tichacek case does not excuse the violation of the anti-dilution provisions in these leases. The court held that what lessees couldn't do was pool the Luecke's interests beyond the authority in the leases. The lessees exceeded the authority granted in the pooling provisions. And we hold that the trial court didn't err by ruling that the lessees failed to comply with the pooling provisions in the leases. The court never held that the drilling of the well constituted a breach. It never held that the well was illegal. It never held that the well was a trespass. Those issues didn't come up at all because that wasn't what was at stake. Unlike in this circumstance, where plaintiffs are alleging that the well is illegal, that drilling the well was a breach, and that drilling the well constituted a trespass. So Luecke is completely inapplicable here. And specifically, it never holds, as plaintiffs claim in their motion, that Browning's completion of a horizontal well without pooling the tracts violated the terms of the Luecke's lease. The court never held that. So let's go on to the next allegation that the plaintiffs make constituted a breach of the lease. That by pooling plaintiffs' interests in an oil well, Magnolia breached the lease. They have 2 theories about how plaintiffs' interests were pooled in an oil well, even though Magnolia says they absolutely weren't. The first is the argument that there is no functional distinction between pooling and a multi-tract horizontal well. They are the same thing. But this is completely wrong. And let's go through in some detail why. First, let's look once again at the Luecke case. The Luecke case devoted an entire section of the opinion to discussing what pooling is. The section is called Pooled Units. And they list several elements that are necessary components of pooling. The first element is pooling allows a lessee to join land from 2 or more leases into a single unit. Well, that applies here. That's true. Magnolia did combine two or more leases into a single unit. But then it goes on to list additional elements of pooling. Operations anywhere within the unit are treated as if they occurred on all the land within the unit. Not the case here. No one has ever claimed that's the case. It's not the case. Third element, production from the well on a pooled unit is treated as occurring on all the tracts pooled into the unit. Again, absolutely not the case here. No one contends that, not plaintiffs and not Magnolia. Fourth, with regard to the royalty interest owners, pooling results in a cross conveyance. Now, Mr. Alicon spent a lot of time parsing why cross conveyance may or may not be a component of pooling. The fact is, the case law expressly says that it is. Lastly, royalty is distributed on the basis of proportion of each party's acreage bears to the whole block. Neither 4 or 5 are present in this case either. Nobody contends that there's a cross conveyance here, and nobody contends that the OPLs are bound to be paid in this manner with respect to acreage. So of the 5 elements of pooling, only 1 is present. And so therefore, merely combining tracts alone does not constitute pooling. You need these others. And it's not just Luecke that emphasizes these other elements. Texas Supreme Court in 1999, the primary legal consequence of pooling is the production and operations anywhere are treated as if they've taken place on each tract, not present here. And then 1968, Supreme Court, this court has held that pooling affects a cross conveyance. Neither of these holdings have ever been disclaimed. They're the law in Texas. That's what pooling is. Now, there are times when pooling is necessary, precisely because of these additional elements of pooling beyond merely combining tracts. Let's look at an example. Let's say that you want to drill a vertical well on the left tract, but in order to have a big enough drilling unit, you need to combine the producing tract on the left with the non-producing tract on the right. Now, merely combining the tracts to create the drilling unit, as was done here with respect to an oil well and the OPL's interests, merely combining the tracts to create the drilling unit is not enough to drill the well, because under Texas law, royalties can only go to the lessors on the producing tract. So this is a vertical well, right? And so the production would only be on this tract, and under Texas law, only these royalty owners could get paid. Similarly, the production and operations on the producing tract will not hold the lease on the non-producing tract. So to drill the well, you need to do more than simply combine the tracts into a drilling unit. What more do you need to do? You need to pool the tracts as well. When you pool the tracts, you now have the right to pay the lessors on the non-producing tract some of the royalties that would have gone to the lessors on the producing tract. And when you pool the tracts, the operator has the right to hold the non-producing lease by production and operations that are happening on the producing tract. These are rights that the lessee normally wouldn't have. And so that's why the law requires the lessee to have special permission in the lease to pool. But if we turn to our situation here, we see that all that is necessary to drill this well is merely combining the 3 tracts to form the drilling unit. We don't need any of the extra elements that constitute pooling to drill the well. Why? Because the audio well produces oil and gas from all 3 tracts, making all 3 tracts producing tracts, meaning that royalties can be paid to the royalty owners on all 3 tracts based on the production coming from their respective tracts, and meaning the production and operations on each tract hold the leases on each tract. So we don't need the extra elements of pooling in order to drill the well. And so we don't need pooling authority to drill the well. What these examples show is that pooling is not the same thing as merely combining tracts to form a drilling unit. It's more than that. And so Magnolia did not need to, and so did not, pool plaintiffs' interests in an oil well merely by combining the tracts to form a single drilling unit. Now, we heard Mr. Alicron insist that Magnolia did pool plaintiffs' interest in an oil well because Magnolia filed a pooling designation that included the South lease. But the undeniable fact here is that nothing in the pooling designation specifically states that Magnolia is pooling plaintiff's interests in an oil well. Now, I just explained why Magnolia didn't need to pool any interest in order to drill the well. So Your Honor might be thinking, well, then why did they file a pooling designation? And that's a reasonable question. But sometimes a lessee will pool anyway when they have the authority to, because pooling brings certain advantages, even if it's not strictly necessary. One advantage, for example, is that you now have an explicit formula for paying royalties to each interest owner that binds all the interest owners. That's an advantage of pooling. You don't need it, but it's nice to have. But the lessee can only pool the interests that he has the authority to pool. There's no dispute about that. And that's what Magnolia did here. So what did Magnolia pool by this pooling designation? What the pooling designation does is pool all royalty interests in a gas well. For example, the audio well could have turned out to be a gas well, or it could turn from an oil well to a gas well, in which case pooling would take effect. Now remember, these designations are filed before the well is drilled or before it's producing. And so they don't know whether it's going to be an oil well or a gas well. Or even if they did, it can always turn from one to the other. And so it's important when you file a pooling designation to account for that. And so to the extent that this well initially came on as a gas well or eventually turned into a gas well, Magnolia wanted to pool it, and it absolutely has the right. Plaintiffs have never contested the idea that the lease grants the right to Magnolia to pool their interests as to a gas well. Okay. The pooling designation also pools the other interest owners that Mr. Hanna talked about as to gas, but also as to oil. Now let's drill down a little bit deeper here. As Mr. Hanna explained, the royalty interest in the South Tract is divided up among numerous owners based on the deed through which they acquired the royalty interest. And as Mr. Hanna is going to explain later in the trespass section, these deeds give the different interest owners different rights to authorize pooling. Now, as I said, no one disputes that Magnolia has the absolute authority to pool all of the interests in a gas well, including the plaintiff's interests. And that's what the pooling designation does. Now, there is a dispute between the parties about whether the interest owners connected to Deed 1 and Deed 2 can authorize Magnolia to pool for an oil well. But Magnolia absolutely believes it has the right to do so, as Mr. Hanna will explain, and the designation pools those interests in an oil well. But what the designation never does, and what Magnolia has never said that it does, is pool plaintiff's interests in an oil well. And let me add one final note on this issue. If there really is some sort of ambiguity or confusion about whether this pooling designation pools plaintiff's interest in an oil well, I stand here today to say that Magnolia would be more than happy to file whatever paperwork would be necessary to satisfy plaintiffs to make it absolutely clear that plaintiffs' interests in an oil well are not pooled and they are in no way bound by this designation with respect to an oil well, because they're not. So to summarize, these are the 5 elements of pooling. Only one element is met here as to plaintiff's interest in an oil well. None of the others are present, and so there's no unauthorized pooling here. All right, next. Plaintiffs allege that drilling the multi-tract well results in an improper commingling of production, and that this is somehow a breach. They specifically argue that no provision in the lease allows the commingling of oil and gas produced from the lease premises with oil and gas produced from other leases or lands. Now, they cite nothing in Texas law that stands for the proposition that the lessee needs such authorization. Recall, we talked about what a fee simple determinable does. It gives the owner all power except that which is prohibited or reserved. So the question isn't whether there's a provision that allows it. The question is whether there's a provision that prevents it, and there isn't. And Professor Smith has spoken to precisely this issue and the extent to which this allegation just misunderstands what a royalty owner is entitled to. The owner isn't entitled to the specific molecules of the oil and gas below the surface, but to a fair chance to recover the oil and gas in or under his land or their equivalent in kind. The issue is not whether you get paid royalty on a specific molecule, it's whether you get paid on the right amount. Excuse me. Otherwise, it makes no difference. And as we'll see in a second, it absolutely is the case that that's what Magnolia is playing plaintiff's royalty on. And that takes us into the last of their allegations, that somehow paying royalties on an estimated volume is not allowed by the lease. Again, they specifically say no provision of the lease allows payment of royalties based on an estimated volume of oil and gas produced from the leased premises. Again, this misunderstands the nature of an oil and gas leasehold. It's not a question of whether it allows it, it's a question of whether it prohibits it, and nothing in the lease prohibits it. The question is, what does the lease say about how royalties are going to be paid? And it says royalties to be paid by lessee are on oil, 1/8 of produced and saved from the land. Now, what does that mean under Texas law? What does that obligate the lessee to do? The Luecke case addresses this. Under Texas law, a lessee complies with this requirement, by paying royalty on the production that can be attributed to the lessor's tract with reasonable probability. Let's look at the specific language they use. In this case, speaking of the lease's royalty provision, they say it specifies a 1/8 royalty on oil produced and saved from the land and on gas produced from said land. Very similar to the language in the South lease. And so what does that mean? It means that lessors are entitled to royalties as specified in the lease, compelling a determination of what production can be attributed to their tracts with reasonable probability. So not only is it not the case that Texas law forbids the lessee from paying on an estimated volume of oil and gas, it expressly contemplates that possibility as the lessee's obligation. And so we've seen these 4 allegations to support breach of the lease here. And we've seen that not one of them has merit. For that reason, their claim to summary judgment on breach should be denied. Thank you.
Okay, and trespass is next. You're muted, Mr. Allocation.
Your Honor, trespass is next, but if I may just very briefly respond to some of the points.
Certainly.
Raised. The first that I want to discuss, Your Honor, is Mr. Hanna's reliance on or invocation of the Railroad Commission, the Railroad Commission's findings. I want to show the court what defendants argued at the Railroad Commission and what the Railroad Commission actually determined. So I'm sharing my screen, and as you can see here at the Railroad Commission, this is a transcript from a hearing at the commission. The defendants said to the commission, this is really a complaint about whether the lease has been breached. That's a courthouse fight. They've filed a lawsuit in Karnes County, and that's something the court in Karnes County can decide. This is not something that the commission has jurisdiction to decide. And the commission agreed with the defendants on that and said in our Exhibit 9 at page 22, while the Opielos may have a bona fide lease dispute with Magnolia, the determination of whether there has been a breach and the appropriate remedy is outside the jurisdiction of the commission. So, you know, they bring up the commission's findings, but really what the commission did was punt the ball to you. So those issues have not been approved by the commission and are before this court for determination. The second thing I want to address is the defendants' policy-based arguments. You know, they say that.
Okay, and I'll just say that I understand that That's for the legislature, the Railroad Commission, and possibly the Texas Supreme Court, and not for the district court to get into the weeds on what would be a good idea to do as opposed to what the law compels right now.
Right, and the one thing that I would like to point out is Mr. Hanna said that we're saying that all allocation and PSA wells are legal. And that is not our position. Mr. Hanna said some of those allocation and PSA wells have 100% sign up from the royalty owner. Just because a well is permitted as an allocation or a PSA well doesn't mean that the royalty owners disagree with the well being drilled. And in fact, I'd assume that in almost every single one of those wells, the royalty owners have all signed the leasing orders, which have ratified the well. So, you know, this argument that we're trying to make all the wells legal in Texas and the court rules in our favor, the Texas oil and gas industry and America's energy independence is going to come crashing down. That's just not what's happening. We have a very specific lease that prohibits pollution, and that's all we're asking the court to do. Third thing I want to address is, you know, in his opening remarks, Mr. Hanna said that we're trying to oversimplify the case. And then Mr. Lauer said that drilling a horizontal well is like building a house on 2 tracks. That's not an oversimplification. I don't know what is. But what he's saying is that an oil and gas lease, because it conveys a fee simple determinable, they can do whatever they want. They can drill any well that is economic, and that's not true. And Texas courts have always held that even when the lease is silent on pooling, that a lessee needs express pooling authority to pool property. So this argument that so long as the lease doesn't prohibit this well, that it's allowed, that's just contrary to decades of Texas case law. And in our reply, we cite the 2017 case from Sampson, in which the court reiterated its holding that for an operator to pool land needs the lessor's express authority. And of course, their argument that they can do whatever is not expressly prohibited in the lease is not really applicable in this case because the lease expressly prohibits pooling. So even if, you know, that wasn't the law, the lease here does expressly prohibit it. Another thing on going back on the Luecke or Luecke case, they make the argument that the court held that the operator breached the lease not by drilling the well, but merely by pooling and insisting that the Luecke's interests were pooled. So I think the argument that they're making is, had Browning Oil Company just drilled the well and not gone through the formality of pooling the interest, or purporting to pool the interest, that there would not have been a breach. And nothing in the holding, nothing in the opinion of that case suggests that it was limited to such a narrow technicality. In fact, the court said that when an operator finds itself in this situation, in which it needs additional acreage to drill a profitable well, it has 2 options. And those 2 options are to negotiate with the lessor to get the pooling authority that it needs, or it can forego drilling. It didn't say, well, you know, you messed up by pooling the interest. You should have just drilled the well without saying that you pooled it. And that argument really is a distinction without a difference in this case. And that brings me to my next point. In this case, like in Luecke, the defendants did purport to pool the interest. Now, they now argue in this litigation that Magnolia does not claim that the plaintiff's interests are pooled. Let's look at what the pooled unit designation says. I'm going to share my screen. It says, this agreement covers all production from the land described on Exhibit B. And Exhibit B describes the OPL as land. They talk about some of the hallmarks of pooling. This pooled unit designation says, production from the unit shall be allocated proportionately among the tracts within the unit in the proportion with the number of surface acres in each of such tract. That's one of the hallmarks that they claim is necessary for pooling. again, these hallmarks aren't necessary for something to be considered pooling, but they purported to do that here. They also say the production of oil, gas, and liquid hydrocarbons in any part of the unit shall constitute production of such substances from all of them. So they purported to do a pooling, and they make this argument that they didn't include the plaintiff's interest. The problem with that argument, Your Honor, is MPRI owners cannot validate a pooled unit without the lessor's consent. And Texas cases all say that the lessee needs express pooling authority from the lessor. And the only lessor in the OPL lease are the OPLers. And they have not given that authority. Now there is a disagreement on whether these MPRI owners are MPRI owners or co-tenant mineral owners, as I explained earlier, and I won't go into that again. They are MPRI owners. And the argument that MPRI owners can validate a full unit without the lessor joining in it's so out of touch with the law that no court has ever considered the notion. And the only authority that I could find that even discusses that notion is a law review article back from the 40s, in which the author wrote an article about non-participating royalty interests. And he said, it might be interesting if there were a case in which someone with a term NPRI, that is a term that expires when production ceases, if somebody with a term NPRI could perpetuate their term NPRI by agreeing to a pooled unit in which the lessor hasn't agreed to the pooling. And the author said, well, no, of course that can't happen. Right? Of course, a non-executive interest owner cannot pool without the executive's consent. But that's what Magnolia is saying that they did here. They're saying, well, the lessor didn't give us express pooling authority, but these MPRI owners did. So yeah, that argument is just incorrect. Then the last thing I want to discuss before I move on to trespass is their argument that so long as the lease doesn't expressly prohibit commingling of production and payment on an estimated royalty, that they're allowed to do that. That's just contrary with Texas law, in particular the regulations that were in place at the time this lease was executed. Rule 26 says that an operator needs to measure production before it leaves the lease. And when you have a lease that prohibits pooling, that prohibition of pooling in conjunction with Rule 26 ensures that the lessor is going to get paid a royalty based on actual measured production from his tract, not from an estimation of commingled production. And, when you have PSAs or pooling provisions, those agreements provide for how royalties are going to be allocated. But in the absence of those agreements, there is just no way. No way to calculate that. It's just take the operator at its word. And then one last thing, Mr. Lauer said that the court in Luecke said that Texas law this case said that operators are allowed to commingle production, produce it, and then allocate production amongst the different tracts. Now, the court did have some language that suggested that, but the court also held that there was a breach of the lease, and it remanded for a proper determination on remedies. And the court in the footnote said, we're not saying that this is the only remedy and measure of damages available. That's in footnote 30 of that opinion. So what the court said is one measure of damages is the production that should have been allocated to the tract, and now the defendants have the burden of proof on that. They've commingled production, and generally when somebody commingles goods, the person that commingles goods has the burden of proving what the aliquot share is. But that's not the only measure of damages, right? I mean, our clients have property rights that have been taken because of this breach of the lease. Another measure of damages is what could they have gotten had the defendants followed the lease, done what the court in Luecke had said, and negotiated and sought a mutually beneficial compromise. And that actually is a good segue into our trespass claim. Now, the defendants have entered our client's property and drilled a well that is not authorized by the lease. That is an unauthorized entry and is therefore a trespass. In the article by Professor Brett Wells that we discussed and that the defendants have discussed, Professor Wells says when that happens, a trespass has been committed. And the problem really with what's happened in this case is the defendants have entered onto our client's property claiming to own rights that are owned by our client and not by the defendants. And because they have done that, they need to compensate our client for those rights. And that's really the long and short of our trespass case. The trespass was in bad faith because there was an action pending. When somebody enters onto property and when an action is pending against them, it's bad faith trespass as a matter of law. We cite the Benavides case out of the San Antonio Court of Appeals for that.
And let me ask, do I have a copy of the pooling designation?
Yes, Your Honor, it's Exhibit 12 to our motion.
Right, it says designation of unit.
Yes, for the Audioslave unit. And I'll note that the well is called the Audioslave well.
Okay, all right. Go ahead.
So, Judge, for those reasons, we'd ask that the court grant our motion for summary judgment. And we can move to the next phase of the case, which will be a determination of damages and what the proper remedy is.
All right, and who's going to respond on this issue?
I will, Your Honor.
Go ahead, Mr. Hannon.
Thank you. Your Honor, the plaintiff's claim for trespass on summary judgment rests on a three-legged stool. And the first leg is that a multi-tract well is necessarily pooling. The second is that that's a breach of their lease. And the third is that any breach of the lease is also a trespass. As Mr. Lauer explained, there is no breach. And so the first two legs of the stool fall apart and the stool falls over, but the third leg also doesn't stand up. There's really no case law to support the plaintiff's position here. I'm going to share again. So the OPL has owned two interests from which they could potentially assert some kind of trespass. Mr. OPL owns the surface, and then they both own a reversionary interest in the mineral estate and a royalty interest. And we're going to start with mineral trespass because they assert both types. And it's important to look quickly at what rights do the parties actually have. And I think, and the court is familiar with this. During the fee simple determinable, the plaintiffs have a royalty interest and a possibility of reversion. They don't have a possessory right. That's black letter Texas law. Magnolia, on the other hand, has the exclusive possessory right. So Magnolia is the one with the right to actually drill and operate and mine and produce the minerals. Magnolia has the possessory right in the minerals. Now, what that means is that if they want to sue, if a lessor during the term of the lease wants to sue for trespass, they have to plead and prove a special kind of trespass. You can't go with the normal trespass case, which is any entry is presumed to have injured if it was unauthorized. Instead, you've got to establish standing by showing in a special kind of trespass called trespass on the case. You have to show an actual and permanent harm to your royalty interest or your reversionary interest. And that's a matter of standing. And the plaintiffs don't even mention this standard for establishing the type of case that they're pursuing. In their brief, they only quote to a footnote from Coastal versus Garza, the controlling case on this issue, that quotes the traditional trespass standard. But they leave out the sentence that footnote is in the middle of, which explains that this is only for trespass on the case if you're a mineral lessor, and that requires actual injury. Now there, what the court found is that Salinas, the lessor, didn't have a claim for damages on his reversionary interest or his royalty interest because the rule of capture said it was okay that some proppant and frac fluids went onto his tract during the term of his lease. That's not something that he can recover, so he doesn't have an actionable claim for trespass. And here, the plaintiffs don't contest that their lease is a valid and subsisting lease. So they would have to show how their royalty interest has been harmed or their reversionary interest has been harmed. They don't make a royalty claim that there's no summary judgment evidence or argument that their royalty interest has been harmed. Because again, Magnolia is ready and willing to pay the royalty that they're entitled to, and there's no evidence on summary judgment. And again, you have to have evidence because it's a standing issue. There's no evidence on summary judgment that their royalty interest has been harmed. They're going to get the 1/8 royalty they're entitled to under the lease. But if you read their reply, what do they say is the problem with their royalty? They say it's that it's a 1/8 lease, and what they really want is a quarter. So they're asking for more. There's really no question that they're going to get the royalty that they're entitled to under the lease, and not getting as much as you would like under a fictional lease that might have existed today is not a claim for damages. Then on their reversionary interest, they don't make any argument that it's been harmed. And in fact, the only summary judgment evidence is that this well slots right into that Karn's trough that we talked about earlier, and it is the prudent operator way to develop the minerals. There's no doubt about that. So there's no harm to the reversionary interest or the royalty interest, and therefore they don't have standing. But let's say they get past that and we go to look at the elements of a trespass claim. The next thing that they've got to prove, and the burden of proof is on them, is to show that the entry was wrongful. That's black letter Texas law from 2015. Supreme Court said it's the plaintiff's burden of proof to establish that the entry was unauthorized or without consent. Here, they can't meet that burden of proof. In fact, their own summary judgment evidence is a copy of the lease, which is all of the authorization that Magnolia needs to enter and develop the minerals. That Magnolia has an assignment of the minerals, and they've got an express easement to go on the lease and drill and produce. So both under their rights as the fee simple determinable owner of the minerals and under the terms of the lease, Magnolia is authorized to enter. Now, the plaintiffs don't cite any case in which a lessee has ever been held liable for trespassing on its own lease. Every single case that they cite, and this is the entire list, is either not a case about an oil and gas lease, or the court held or the lease at issue had expired. In other words, the operator of the well was held to have trespassed because it didn't have a lease. There's not a case that they cite where someone trespassed on a lease that they owned. The case that they cite and the case that the Brett Wells article talks about for this theory, and the plaintiff's theory, if you want to entertain it, is if you claim some right under the lease that you don't have, you must be trespassing. And they cite Humble versus Kishy for that. What was the fact in Humble versus Kishy? Was Humble claiming that it had a lease and the lease gave it the power to do something that it did, and it turns out it didn't have that power? No. Humble entered after the expiration of the lease and drilled a well. The lease had expired. So it's not that Humble said, oh, I'm claiming some right within this lease. It's that Humble thought it had a lease, but it didn't. No case has ever held that a lessee trespassed on its own lease. The next reason they can't prove that the entry was unauthorized is that their co-tenants have authorized the entry. Now, we've talked a lot about these other 75% owners. And if you read it was the first thing Mr. Alarcon led with when he started his argument this morning. And if you read their reply brief, you'll see that it takes up a big part of their reply brief. Why are they working so hard to undercut the rights of these owners who aren't a party to this case? The answer is pretty clear. If it's true, if you take them at their word, and it's true that you need, as the operator of a lease, some authority, some special authority to drill a multi-tract well from the underlying mineral owner. Magnolia has that from the other owners in this lease. So what they ask you to do is ignore the terms of the underlying deeds. They ask you to interpret this deed without the parties present, and then ignore the words in this deed. But deed 1 is pretty clear. It says that grantor reserved the rights of ingress and egress, so that's the right to go on and off the lease, for the purpose of mining and drilling and exploring, and removing the oil and gas. That's a possessory development right. Now, right now, this is subject to a lease, but the plaintiff's position is that the underlying owner of the minerals has to give some sort of pooling authority or some other authority to drill a multi-tract well. Well, if that's the case, Magnolia has it. And Magnolia has it from a co-tenant. And the black letter law in Texas, I cite Byram versus Penley here. There's a recent case from the San Antonio Court of Appeals upholding this, that each co-tenant has the right to enter the common estate and a corollary right to produce the minerals, even over the objection of the other co-tenants. So the other 75% of the owners have said, you know what, we want this well. We want production. Please come drill it. The plaintiffs are trying to stand in the way of that. They're trying to be a holdout so that they can go get a higher lease royalty. And the law in Texas says that's not how it works. One co-tenant can't be a holdout and frustrate development on behalf of the other co-tenants, because that would freeze up oil and gas production in Texas. And we want to maximize the production of our natural resources. They ask you to ignore the words of the lease. Again, I don't think this court should be interpreting this lease without the parties present. But Day & Co. versus Texland makes it clear that you only apply the presumptions that the plaintiffs are trying to apply when the lease is silent. If a lease expressly says what's conveyed and what's reserved, you follow the words of the lease. In the deed. Next, quickly on bad faith trespass. There's literally only one fact that matters for bad faith trespass. Again, it's that Magnolia has a valid oil and gas lease. The lease is unquestionably in force and gives Magnolia the right to enter. The plaintiffs, again, they don't cite any case where a court has held an operator with a lease to have trespassed, much less trespassed in bad faith. Because the doctrine of bad faith trespass is about an operator who drills a well with no lease from the co-tenant and no lease from the complaining owner. Each case that they cite is about either a lease that terminated or about a lease that failed because the lessor lacked title. So the lessee thought he had title, drilled a well, turns out he doesn't. And it's important when we think about bad faith trespass to ask ourselves, why are they asking for bad faith trespass? Well, the reason is the remedy. The remedy for a bad faith trespass is that the well has to be handed over free of all costs. So the plaintiff or the title owner would get a free well, and it's a windfall because you have now a producing well that's been drilled, and they get the gross production value from that well without having to bear any of the drilling expenses or any of the operating expenses for that well.
Well, that is if they can find a way to get their oil from their property line to the surface across other tracts.
And so the way that the plaintiffs in this case have tried to wire around that is they've just said, you know what, go ahead and produce the well, but give us the gross production value of everything from our tract. Not a royalty rate. Give us the entire production and free of all costs. Excuse me. Now, it doesn't make any sense. Would we continue to operate a well where somebody else is entitled to all the revenues? No, because the logic for bad faith trespass only works. This doctrine only exists where an operator comes in and drills a well where it thought it had a lease and it turns out the title failed or the lease had expired. It's never been applied to a situation where the operator had a lease. Why? Because the operator owns the minerals. It's the operator's fee simple determinable in the minerals. So there's really just no basis in law or fact for trespass or bad faith trespass. It's never been held in these kind of circumstances. So that's mineral trespass. They also assert a surface trespass claim, and I want to just talk quickly about that as well. So Mr. Opiella owns the surface, and here he does have a possessory right. So what are his rights? He's got a possessory right in the surface and subsurface. And Magnolia has here, in the context of a surface use, Magnolia has the dominant estate. So as you know, that Magnolia, that means Magnolia has the right as a matter of law to enter and use as much of the surface as is reasonably necessary to produce Magnolia's minerals, as Magnolia owns the minerals in place. And then Magnolia has the express easements in the lease that expressly authorize Magnolia to go on the property and produce its well. Here again, Mr. Opiella lacks standing because what he's complaining about is fundamentally an interest onto the mineral estate, not an interest on the surface estate. The surface and subsurface trespass cases that Texas courts have addressed have been in situations like pipelines, disposing water into the subsurface, or producing water to use for the operations. They've been about things that are inherently surface rights. But what is Magnolia doing under Mr. Opiella's land? It's producing. It's doing something that is inherently fundamental to the mineral estate by producing a well. So the only reason this wellbore is here is not an easement. We're not passing through someone else's property. It's that we're here to produce. These are where the perfs are. Now, Mr. Opiella's reply brief argues that this is like a, think of it like a pipeline. It cites to the Delhi versus Dixon case. And what Delhi versus Dixon said, the Supreme Court said, is that if you have a pipeline on a surface, it can be used to benefit and transport the minerals produced from that surface, but it can't be used to benefit and transport minerals from other properties. If you transport minerals from other properties, it becomes an excess surface use. So this must be like a pipeline that's an excess surface use because it's being used to benefit other properties. But where is the oil going? If we want to say that this is like a pipeline, again, I don't think it is because it's a producing well. It's not a surface use, it's a mineral use. But if we want to say it's like a pipeline, where is the oil going? It's getting produced from Mr. Opiella's tract, and it's going directly off of his tract and up the wellbore on other tracts. It is not that any other oil is being produced from further down and transferring through Mr. Opiella's property. So even if that analogy were to apply, the facts don't fit it. There's no greater surface use on Mr. Opiella's tract. Now, the Supreme Court's recent decision in Lightning versus Anadarko helps with the understanding of this. So there you had Lightning took a lease on tract 1. Okay, Lightning was the mineral owner in tract 1. The surface owner in Tract 1 was Briscoe Ranch. Anadarko comes in and takes a lease on Tract 2. But Tract 2's surface is being used for wildlife conservation. So Anadarko can't reasonably drill its wells on an area that's a wildlife conservation easement. What does Anadarko do? It needs to access its minerals. It goes and gets a surface and subsurface use agreement from Briscoe Ranch. And Briscoe Ranch allows Anadarko as the surface owner. Briscoe Ranch isn't the mineral owner, but as the surface owner says, it's okay to drill through our surface to access your minerals next door. Anadarko then proposes to do that. Lightning sues Anadarko. The Supreme Court and Lightning's position is, look, you're going to drill through my minerals, and you need to come ask me for permission, not just Briscoe Ranch. Supreme Court disagrees with Lightning and says, no, the surface owner can allow that, but because Anadarko is going to go complete and use the mineral estate on its minerals, but is only using the surface estate on Tract 1. Well, let's kind of apply that to this case. Let's say that the perfs were over here only on under Mr. Opiella's surface. We know that's legal because Magnolia has the fee simple determinable. And let's say that there were no perfs anywhere else. This is Lightning versus Anadarko. This is unquestionably, under black letter Texas law, an okay use if Magnolia had easements from the surface owners of the North Tract and the Highway Tract. So this would be okay. We're producing from this tract. Now, Mr. Opiella says it's somehow transferred into an excessive use when we do this. We add additional perfs on other tracts. Now it's become an excessive use of Mr. Opiella's surface. How is that the case? The well is completed exactly the same. The perfs are in exactly the same place. There's no additional burden on his surface. And in fact, if we think about this, the surface use, the benefit, the burden on the surface is far less than if Magnolia slid the whole well onto Mr. Opiella's surface. Because if we did that, he'd have pipelines, a rig moving in, a well pad, trucks moving in and out. And instead, the entire well is 10,000 feet below the surface where he can't see it, hear it, or feel it. There's simply no excess surface use. So where does that leave us? You know, the takeaway on this is that whether you're talking about trespass or breach of lease, the plaintiffs don't have any precedent for what they're asking this court to do. They don't have any court that's held that a multi-tract well is a violation. Mr. Alarcon, we just heard him argue that there's a regulatory violation, that this violates Rule 26. But the regulator said there is no violation of Rule 26. They said, quote, we are not persuaded by that argument. There is no precedent for a lessee to have trespassed on its own lease. There's no precedent for bad faith trespass, and there's no precedent for surface trespass. Everything they're asking this court to do is move Texas law in a new direction it's never been, and there's no existing support for that in the law. So we'd ask the court to deny the plaintiff's motion for summary judgment.
All right, and let me ask you, Mr. Hanna, where in the pooling designation do you exclude the Opiella's interest, the designation of Audioslave unit?
So the pooling designation does not expressly exclude the plaintiff's interest. The pooling designation says these are the tracts that are leased, the substances that are leased, that are pooled, the substances that are pooled, and the leases that are pooled. And what we're saying is there's no controversy and no dispute about whether the plaintiff's interest in an oil well is pooled. Because we're not arguing with what Browning argued in the Browning versus Luecke case was they said, we understand that this violates the dilution clause, but we insist that it must be a valid unit because horizontal drilling is special. That's not what we're arguing here. What we're saying is we understand that we don't have the authority to pool for oil for the OPL's interest in that lease. We do have the authority to pool for other interests in that lease, and we do have the authority to pool the OPL's for gas. And in fact, if you look at the production records attached to the plaintiff's summary judgment motion, what you'll see is that this well produces a lot of gas and may, under commission standards, in fact, be a gas well. Now, that's not an issue here. We're not arguing that it's a gas well today. We're conceding for purposes of today's motion that it's an oil well, but we don't argue that they're pooled for oil. We don't disagree that they can't be pooled for oil. And what Mr. Lauer was saying is that if this suit were a suit for, let's say they wanted to clear title because they're concerned that this is out there and it somehow clouds their title. Well, if that was their case, what would their remedy be? It would be something declaring it invalid as to their interest. We would be happy to grant an amendment to the lease that says, okay, as to the OPL's interest in this lease, as to an oil well, it's unpooled, because we simply don't contend that it's pooled as to an oil well. But it's important that the pooling declaration list that lease because there are a lot of interests in that lease that are in fact pooled.
All right, Mr. Khan, anything else?
Yes, Judge, I'll be brief. On this last point that you and Mr. Hunt were just discussing, so they now concede that the OPL's interest is unpooled. The OPL's interest is the interest of the executive rights. So if the lessor is unpooled, then the lease is unpooled. You can't pool a lease without the lessor's consent. That's black letter Texas law. So I just want to touch on this issue of actual permanent harm. The OPLs have suffered an actual permanent injury as a result of the defendant's conduct. They've lost the ability to negotiate for the pooling rights that were retained by the original lessor. That is a property right. It is a property right with value. And had the defendants followed Texas law, they would have had to negotiate for that right. Mr. Hannon has brought up several times that our clients have asked for an increased royalty. This is an antiquated lease, and if the defendants want to modernize it so that it allows modern drilling technology, then yes.
Yeah, I don't have any problem. I would be, I expect happy to get whatever royalty I was getting, but not happy that it was half of what the neighbors were getting simply because they'd signed their leases 10 years ago instead of 65.
Well, and Judge, there's actually case law in support of our position. There's a case out of the Texas Supreme Court, 1986, under the Mineral Interest Pooling Act. It's the Carson case. We cite it in our reply. Now, under the Mineral Interest Pooling Act, whenever somebody tries to force pool a property owner, as a precondition to force pooling, you need to make a fair and reasonable offer. So in that case, the lessee told the lessor, hey, I want to pull your tract. And the lessor said, that's fine, increase my royalty, make it a modern royalty. And the lessee said, no, we don't have to do that. Went all the way up to the Texas Supreme Court, and the Texas Supreme Court said that as a matter of law, was not a fair and reasonable offer. Have we asked for an increased royalty? Yes, because this is an antiquated lease, and defendants are trying to do 21st century technology with a 1955 lease. And, if they want these additional property rights that they did not negotiate for back in 1955, they have to pay for it one way or another. On the right to enter, a lessee's fee simple determinable gives them the right to enter. That right to enter is subject to the constraints in the lease. The lease prohibits a certain type of drilling, a certain type of operations, and then the lessee exceeds what the lease allows. That is a trespass. It's an unauthorized entry. And this lease prohibits pooling, and therefore prohibited this well. It is an unauthorized entry that harmed our plaintiff by preventing them from negotiating for their property rights, but it also harmed the surface interest owner because, as I cite some case law in our reply, One of the most cherished rights that a property owner has is the right to exclude. Now, it's called the surface trespass. That's a misnomer. The surface estate isn't only the surface. It's everything except for the actual minerals in place. And Mr. Opiella, as the owner of the surface tract, has the right to exclude unauthorized entries. And that's exactly what this well is.
Could Magnolia have drilled the exact same well if they did what we saw in the Briscoe Ranch case and just didn't perforate it until they got to the Opiella's property line?
Yes, Your Honor.
Under the lease. I mean, it may not have been economically feasible, but.
Right, I haven't given that a lot of thought. That would certainly alleviate the concerns about that you're only getting paid on an estimated amount of production. I think that would probably be fine. But I'm glad you brought up the Briscoe Ranch case, because in that case, the court held that the right to use the subsurface is the right incident to the surface. In that regard, it supports our argument for the surface. And unless the court has any more questions, we'd ask that the court grant our motion for summary judgment and move on to the next phase of this case.
No, I have nothing else right now. I'm going to calendar this for, I want to get this done, this month, certainly, hopefully within a day or two. But the other attorneys are excused, or the attorneys on this case are excused. And let me ask, on the Jacob Zamora criminal case, is Mr. Zamora in probation or in the court or something?
He is currently not. Let me go double check, Your Honor. I'm actually over here at the courthouse. I can double check with probation and see whether or not he's actually shown up. He's been notified by both probation and Mr. Nitz that he is to show at the probation department today.
Your Honor, he's on his way. He had some car trouble. He might even be trying to sign in via Zoom while he travels.
No, I don't want him signing in via Zoom while he's traveling or at all. I want him present. We're going to take a 10-minute break. I'll be back at 11:15.
Your Honor, do you mind if I speak to my witnesses that are on the Zoom just to make sure that they know that this is the correct hearing?
Yes, no, you go ahead. I'll cut my my speakers off.
Yes, Your Honor. Thank you. For all my witnesses, Mr. Ans, all the detectives, this is the right hearing. Judge was just finishing a different thing. So just stay on this, and you can either mute yourself and turn off your video for right now, or if you want to you can just mute yourself and just stay on the video. We'll be back in 10 minutes. The judge will go from there. Okay. Thank you.
Got it.
Lori. Lori. This is Luecke.
Yes, Luecke? Were you asked for speaking to
Mr.
me?
Lamb?
Yes.
Yes. What is the style and the cause number?
The cause number in this case is going to be 1802-0033 CRA. And it's going to be Jacob Zamora, Zamora.
Perfect. Thank you.
Judge, I sent or I uploaded the pre-pack that we had previously to chat.
Thank you. I just downloaded it.
Okay.
Okay, so I have 15 after. Is Mr. Zamora present?
He is not. I have the bailiff here. He'll go double check right now, Judge.
All right, Mr. Nitz.
Your Honor, I have him on the line. He's on his way. Says he's about 5 minutes out.
I'll tell him I don't want him violating traffic laws or anything. We will wait a bit longer. Where does he say he is?
Near Potter Road on Highway 16.
Thank you. Okay, and we have someone online apparently on a cell phone. It says DEP Staging DC 94371. What is your name, sir?
Is that mine, Your Honor? Detective
Oh,
Lawson?
no, the one that I'll get yours in a minute. One that starts with DC. It's the gentleman with the glasses and a gray beard.
That's going to be me, Detective Curry, sir.
All right, and CURRY?
Yes, sir.
All right, thank you. All right, and that was Detective Dawson?
Rawson, Your Honor,
Rawson.
ROSSON, Brian Rawson, badge 2503.
Like the lighter. All right, and there's one more DEP. Doesn't have anyone on it. Starts with an RH94.
Trying to figure this out. It's Detective Hodge, Richard Hodge, badge 2170. Can you?
Yes, and I just muted you. Sorry, I didn't.
Let's see. Okay, I'm unmuted, but I don't see anything but everybody's names.
Okay, I'm seeing boxes with everybody's little Hollywood square.
Okay. My camera shows to be live, but I don't see y'all.
I'm not sure, sir. I've never been on a Zoom meeting like this on the phone.
Okay. Well, if y'all can see me, I'll just keep looking at the camera. I don't see y'all.
Sounds good. You have a Christmas party?
Yeah.
All right.
Your Honor, can I be put in a room with Mr. Lamb briefly?
Yes.
Your Honor, I'm also having the bailiffs do another call out in the meantime.
Thank you. All right, I've opened the breakout rooms. All right, ladies and gentlemen, I need to call an officer on a search warrant I just was looking at. I'm just going to mute my computer for a few moments and I'll get back to you. All right, do we have something to report?
Your Honor, he's here. He's entering the building now. I believe we have an agreed punishment.
Okay.
There was some.
We will, state's gonna ask that before the witnesses are released, that we have everything.
Oh,
taken care
yes, no, I'm sorry for the witnesses, but they're going to remain until this is finalized.
I'm sorry to everybody as well. The bailiff says that he hasn't seen him yet still.
Okay. All right, I'm working on the search warrant still. Go ahead.
Yes, Your Honor. I'm going to step away and double check myself. Thank you. Your Honor,
Yes.
announcement. The bailiff's here with me. He's called out in front and in front of the probation department and in front of the courthouse in both parking lots. The defendant has not shown.
All right, Mr. Nitz, what is his representation to you of what his ETA is?
He said he was in the parking lot.
Okay.
Judge, I've checked both parking lots. There's nobody in front of probation parking lot, and there's nobody in front of the Justice Center parking lot.
We've also double checked with probation.
Okay.
Mr.
No,
Zamora-
I don't doubt you've checked.
No, I'm saying Mr. Zamora has been here in the recent times with the construction and knows how to come to the probation department is what I was going to put on the record, Your Honor.
Okay, thank you. All right, Mr. Nitz, I'll give him until 35 after the hour, which is over a minute from now, and see, that'll give him 35 minutes to be late. And that'll be 25 minutes after he represented that he was 5 minutes away.
I will contact him one more time.
All right, Mr. Nitz, I have 35 after.
That's it.
He said he just walked through the door. He gave away his phone and he walked.
Your Honor, there does seem to be a black Charger in the parking lot. That's what the bailiffs have told me.
Okay. He walked through what door where?
In probation.
All right. Probation, Ms. Ibarra.
He's not through the door in probation, Your Honor. I heard Ms. Ibarra speak. He may be coming through the courthouse doors. I'm not sure. Is it him?
All right. So is he there or not?
Your Honor, let me check with.
Please.
Yes, Your Honor, that is the defendant. He is coming in right now. Ms. Ibarra has confirmed that the defendant's outside. He's going to, I believe he's being escorted in right now, Judge. Your Honor, they're wanting him right now. Ms. Benavides, could you please send the judge the prior plea packet if it hasn't already been done?
I have it.
Oh, okay. Thank you.
You're welcome.
I also have the PSI and the attachments. Okay. Are you Jacob Zamora?
Yes, Your Honor.
Okay. All right. Mr. Nitz, are we still having a contested hearing this morning? Or do you
No,
need-
Your Honor, I believe we have an agreement.
Okay. You want to put that on the record?
Yes, Your Honor. The agreed punishment in this case, Your Honor, is for 5 years in the Texas Department of Criminal Justice Institutional Division with credit for time served. Credit for any of his time that he served.
How much time is that?
I do not know, Your Honor. I will have to get our staff on getting the judgment prepared.
All right. Mr. Zamora, is that your plea bargain agreement with the state?
Yes, sir.
And one additional note, Your Honor, there's a charge out of Bexar County. There's an agreement to dismiss that charge if he agrees to the punishment in this case.
Your Honor, that was not our agreement. That is a discussion with Bexar County's office. If Bexar County's office is okay with dismissing the charge post his plea on this, that is up to Bexar County. We have no jurisdiction on that case.
All right, Mr. Zamora, so do you understand that the district attorney's office in Atascosa County can't make a deal that binds the district attorney's office in Bexar County?
Yes, sir.
And do you still wish to go ahead with the plea bargain you've worked out with the district attorney's office in Atascosa County?
Did you get to ask them, Mr. Nitz?
Can I be put in the breakout room briefly?
Okay.
Mr. Lamb, I believe Mr. Thornton and I had discussed this, and when he was working the case, that's what we had agreed to.
Like I said, it is, if, Your Honor, may I get in a breakout room with Mr. Nitz? Or actually, I can just call him.
Okay, why don't we do that? Because
Yes,
I've already given him a breakout room with his client.
I understand that, Your Honor.
And I'll head into the breakout room with my client.
All right, you're muted, Mr. Nitz.
All right, Your Honor, I explained to my client that the agreement is not binding on this plea offer, but that there is, I just want to note for the record, there is an agreement in Bear County as well, based on his plea here, as it relates to that case in there, in Bear County.
Okay, and has that been communicated to you directly by the Bexar County DA's office?
Yes, Your Honor.
Okay. All right, and so, Mr. Zamora, is that your plea bargain agreement in this case?
Yes, sir.
And do we have an agreement on how many days? I was told.
Not yet, Your Honor. Mr. Trevino has been at the office with our secretaries to get the day's credit. They're on it at this moment.
Okay. Anything else from either side?
Nothing from the state, Your Honor.
Nothing from defense.
Okay. And are you planning on doing a amended plea package with a new waiver, a new plea bargain agreement sheet?
Your Honor, based on the fact that he had already pled open last time and to come to an an agreed punishment, I don't believe it's necessary. But if the court would ask me to.
No, that's fine. I mean, I'm not going to have to defend this on appeal. So, all right then, I will follow the plea bargain agreement in this case. I will find the defendant guilty of the third-degree felony offense of theft and sentence him to 5 years confinement in the Department of Criminal Justice. Is there any reason why a sentence should not now be imposed? Hearing on it is the order, judgment, and decree of the court that the defendant be taken by the sheriff of Atascosa County and transported to the authorized receiving agent of the Department of Criminal Justice. His sentence will commence today. He'll be confined for 5 years. It will run concurrently with any other sentence that he may be under. And you will receive credit for all the time he has spent so far in jail on this count. You understand, sir, that because I've followed the plea bargain agreement that you've worked out with the Atascosa County District Attorney's Office, that you have waived the right to appeal and you may not appeal.
Yes, sir.
Yes, sir, go ahead.
I just wanted to ask if would I be able to have a couple of days out just to get my things in order?
No, sir.
Yes, sir.
I think Mr. Nitz has gotten you an extraordinary deal given your behavior on probation up to and including your arriving to court, not just 35 minutes late, but 35 minutes after the 2 hours extra you were given to show up already.
I apologize, sir. I had my son with my.
Okay.
I was out.
I appreciate the witnesses being here. The witnesses are released, and I will certify to the Court of Appeals that this is now a plea bargain case and that Mr. Zamora has waived the right to appeal and may not appeal. Is the judgment on its way over?
Your Honor, Mr. Trevino?
Roland? Okay, and again, I take it.
Okay.
Bexar County.
I'm sorry, Judge. Stacy's on the phone with the Atascosa County Sheriff's Office getting days credit, and she's working on the judgment right now.
Okay, all right. I will just hang out online. But again, unless all the witnesses know that you are released, I appreciate you being available.
Your Honor, may I have a moment just to tell them on Zoom? Thank you all for being here, for helping us out. If you need anything, please feel free to give me a call. And if you need anything at all, me and Roland are available. So thank you again.
Thank you, everybody. Appreciate it.
Okay, just let me know when you have the judgment. I'll work on my emails and just stay here.
Yes, Your Honor. I will, once I get the judgment, and I will get it over to you. Thank you, Judge.
Lachey, you're welcome to take off. I think we're finished with you. Thank you. And is there a bailiff there to get Mr. Zamoro's thumbprint?
Yes, Your Honor. Ms. Ibarra and George are both here. They will, once I get the judgment, I'm going to be sending you and them a copy so they can get the fingerprints.
Okay, if they will send me the
one with the fingerprints?
Well, just send me a thumbprint and I will attach it to the judgment. I've been trying on these things to use the certified signature feature, and you can go back and add the thumbprint without messing that up.
Okay, so let me see if I can get them to just get a fingerprint and then scan it to you, Your Honor.
Sounds good.
Your Honor.
Yes, yes.
I was just notified by the clerk's office that they're going to be stepping away from the computer for a minute, or I guess, for lunch.
Yes, it's
during
Margaret's
this
birthday, I think.
Yeah, it is. And so I will send you the judgment through email. And then if you want to send it back to me through email, and I can send it to the clerks, or if you want to send it to the clerks via email, they wanted to make sure that it was done via email so that if the chat is closed,
I understand. Okay.
Thank you, Judge. I appreciate it.
And did you get the waivers that I just
Yes.
posted back?
Yes, sir. I downloaded.
Okay, all right.
And Your Honor, the defendant is being fingerprinted by George right now, or it might have just been done on the identifier page. At this point, we're still waiting on the final judgment.
Okay, that's fine.
Do you want him taken into custody and taken to the jail, or?
Yes.
I'll let George know. Thank you, Your Honor.
Okay, and is the thumbprint going to be emailed with the judgment? Is it going to be posted here? You're muted.
Pardon, sorry to that. Miss Ibarra is going to scan that in. It's on, we made an identifier sheet for it, so she should be scanning it in. And
okay,
how is she?
Post it on chat, Your Honor, or do you want me to email it to you?
Tell you what, I'll go ahead and end the meeting unless there's something we need to do.
And we'll just submit it by email, Your Honor.
Please.
Okay. Yes, Your Honor.
Yes, Your Honor.
Right. Anything else,
And
Mr. Nitz?
I'll make sure that it gets to the Joe when I get that, Judge.
All right. Thank you.
You're welcome.
Chris, can I get a copy? Can I be?
Absolutely. Absolutely.
Thank you.
All right.
The civil case was finished, Judge, earlier?
I have to rule, but yes, their argument is finished.
Thank you.